School of Management Studies IGNOU presents an audiobook on the course MMPC-013 Business Law for MBA program. Block 6 Business and Sustainability, Unit 12 Environment Protection and Sustainability, Part 1.
After completing this unit, you should be able to understand the key constitutional provisions in India relating to environment, discuss the international developments in the field of environmental law and its impact on businesses and industries, appreciate the important provisions of Water Act 1974, Air Act 1981, Environment Act 1986 and Forest Act 1980, and describe the major schemes that have been specially implemented for the MSME sector. Introduction. In the past 50 years, the world has developed ample understanding on the relationship between human beings and environment. The Stockholm Declaration, adopted at the United Nations Conference on Environment in Stockholm 1972, placed environmental issues at the forefront of international concerns and marked the start of a dialogue between industrialized and developing countries on the link between economic growth, the pollution of the air, water, oceans, and the well-being of people around the world. In the general debate, special emphasis was placed on the role of corporations as most developing nations protested against the activities of multinational corporations and argued that there was rampant exploitation of natural resources by the developed countries. The need for more effective and less wasteful utilization of natural resources was underlined by several speakers. Since 1972, awareness on environmental issues has steadily increased. Human activities such as deforestation, burning of fossil fuels, changes in land use, rising population, excessive use of natural resources, rampant industrialization have adversely affected the environment. However, such issues often take a back seat in view of industrialization, economic growth, and maximizing profits. In an effort to link economic development and environmental stability, Brundtland Commission published a report titled Our Common Future in 1987, which talks about the concept of sustainable development and defined it as, and I quote, development that meets the needs of the present without compromising the ability of future generations to meet their own needs, unquote. This last decade has seen several important developments in the international arena, which specifically deal with sustainable industrialization, production, and consumption. The 2030 Agenda for Sustainable Development, adopted in September 2015, includes 17 Sustainable Development Goals, specifically SDG 9 and SDG 12, puts the onus of sustainable development not just on the governments but also on other stakeholders like industries, businesses, and consumers. Under the International Framework for Climate Change, Kyoto Protocol and Paris Agreement have both called for the financial assistance from developed countries with more financial resources to those countries that are more vulnerable and are less financially endowed. Further, the Paris Agreement had seen unprecedented participation of several companies, including Mahindra Group from India, showcasing their clean technologies and pledging to reduce greenhouse gas emissions at the Caring for Climate Business Forum. It is important to imbibe a culture of sustainability and profitability with clean and sustainable technologies within the corporate structure. In recent years, realizing the economic impacts of environmental pollution and climate change, even the corporate sector has acknowledged that addressing environmental issues and tackling climate change is key to managing risk and ensuring long-term returns on investment. International Finance Corporation in its report suggests that climate financing cannot be done by governments alone. In fact, private entities are far more suitable to invest in climate-friendly projects. It further states that between 2018 to 2030, 3.4 trillion US dollars of climate investment opportunities in key sectors will arise in South Asia if NDCs are met by countries in the South Asia. Out of this, 3.1 trillion US dollars of opportunities will be presented in India alone. However, the global economy continues to grow, resulting in a possible tripling of resource extraction by 2050. There is widespread increase in population, especially in developing countries, wherein the current world population of 7.3 billion is expected to reach 9.7 billion by 2050. There is increase in global consumption, manufacturing, pollution levels, and we are nowhere near to achieving the target set at the Paris Agreement, that is 1.5 degrees Celsius increase, which will further aggravate the negative impacts on our environment, livelihood, and health. Dealing with such multidisciplinary and cross-sectoral issues requires two-pronged strategy. Firstly, develop proactive legal mechanisms with effective compliance and monitoring for reducing pollution, as well as creating a comprehensive framework of liability and payable damages. And secondly, promoting sustainable industrial development and infrastructure by way of appropriate incentive-based schemes, fiscal policies, and market mechanisms. It is important to note that successful implementation of such measures depends on the collective effort of all the relevant stakeholders, including governments, consumers, along with industries and businesses. Evolution of environmental protection legislation in India. India's approach towards environmental protection was piecemeal and reactive in nature. In response to Stockholm Declaration 1972, Air Prevention and Control of Pollution Act 1981, and Water Prevention and Control of Pollution Act 1974 were introduced. Further, Article 48A and 51G were incorporated in Indian Constitution by way of 42nd Amendment in 1976. It is unfortunate to note that beyond causing continual environmental harms, industries can also be responsible for severe and large-scale disasters, resulting in the deaths of millions of people. India was ill-fated to witness one of the world's worst industrial disasters in the form of Bhopal gas tragedy in 1984, killing thousands of people. This incident was a turning point for environmental jurisprudence in India. Several prominent legislations, rules, notifications were adopted after this incident, taking into account issues and challenges that increasingly emerged as part of modern day developments. India experienced a virtual explosion of public interest litigations, specifically on environmental issues, and courts also assumed a more proactive role in the form of public educator, policymaker, and administrator. India even started contemplating on having a specialized tribunal dealing specifically with environmental matters as the Supreme Court stressed on its importance in numerous instances. Finally, after much deliberation and failed attempts, National Green Tribunal was established in 2010. Since its inception, it has played an important role in shaping the environmental litigation in India. Thus, India started adopting a more holistic and comprehensive approach towards environmental protection and regulating the pollution emanating from industries. Constitutional provisions for environmental protection. The Indian Constitution is a living document which has evolved and grown with time. Substantive provisions for environmental rights and duties were lacking in our original constitution. However, its landscape was changed by way of 42nd Amendment, which introduced specific provisions for environmental protection in the form of directive principles of state policy and fundamental duties. With the introduction of these two articles, both the state and the citizens are now under the constitutional obligation to protect, preserve, and safeguard the environment. Article 21 of the Indian Constitution states that, and I quote, "No person shall be deprived of his life or personal liberty except according to procedure established by law." Unquote. Supreme Court in the case of Virender Gaur ORS versus State of Haryana interpreted the word life in a liberal manner and stated that, and I quote, Article 21 protects right to life as a fundamental right. Enjoyment of life and its attainment, including their right to life with human dignity, encompasses within its ambit the protection and preservation of environment, ecological balance free from pollution of air and water, sanitation without which life cannot be enjoyed. Any contra acts or actions that would cause environmental, ecological, air, water pollution, etc. should be regarded as amounting to violation of Article 21. Unquote. Further, in the case of MC Mehta versus Union of India, the Supreme Court treated the right to live in healthy and pollution-free environment as a part of fundamental right to life under Article 21 of the Constitution. Public interest litigations under Article 32 and Article 226 also resulted in a wave of environmental litigations, producing a rich environmental jurisprudence in India. Thus, India's constitution now guarantees a right to healthy environment, right to clean air, right to clean water, etc. Article 19, Clause 1G of the Indian Constitution confers fundamental right on every citizen to practice any profession or to carry on any occupation, trade, or business. However, it is subjected to reasonable restrictions. In the case of Burra Bazaar Fireworks Dealers Association versus Commissioner of Police Calcutta, it was held that, and I quote, Article 19, Clause 1G of the Constitution of India does not guarantee the fundamental right to carry on trade or business which creates pollution or which takes away that community's safety, health, and peace. Unquote. environmental framework in India and its impact on businesses and industries. In the present section, we will be dealing with the Environment Protection Act 1986, Water Prevention and Control of Pollution Act 1974, Air Prevention and Control of Pollution Act 1981, Forest Conservation Act 1980, and the Wildlife Protection Act 1972, etc. Number 1. Water Prevention and Control of Pollution Act 1974. In order to deal with the issue of water pollution, the Water Act was enacted in 1974 with the primary objective of prevention and control of water pollution and maintaining or restoring the wholesomeness of water. The Act specifically prohibits the disposal of any poisonous, noxious, or polluting matter directly or indirectly into any stream, well, sewer, or land. In order to achieve its objective, it established central and state pollution control boards with the function of developing standards for effluents and sewage as well as the quality of water, etc. It empowers the state boards to obtain information from any establishment regarding its construction, installation, or operation with a view to prevent and control water pollution. It also authorizes the state boards to take water samples from any stream, well, sewage, or trade effluent passing through any plant or vessel. The Act further authorizes the state boards to enter and inspect any plant, record, register, or document in order to determine whether the orders or directions of boards have been complied with or not. With regard to the power of entry and inspection, the state boards shall have the powers of district magistrate under Section 94 of CRPC relating to search and seizure. It is important to point that if an offence is committed under this Act by a company, then every person who at the time of offence was responsible for the affairs of the company or in charge thereof shall be guilty of the offence and punished accordingly. The Act provides for a wide array of penalties ranging from imprisonment of 3 months to 6 years and daily fines as well in case of continuous violations. Consent to establish and consent to operate establishment of any industry, operation or process which is likely to discharge sewage or trade effluent into a stream, well, sewer or land requires prior consent of the board. Number 2. Air Prevention and Control of Pollution Act 1981. The Act was enacted in 1981 to provide for the prevention, control, and abatement of air pollution in India. In the case of New Era High School versus State of Bihar, it was stated that, and I quote, statute mandates board to inspect air pollution control areas at intervals, assess quality of air therein, and take steps for prevention, control, and abatement of air pollution in such areas. Unquote. The Act includes noise pollution. It specifically prohibits the industries from emitting air pollutants in excess of the standards laid down by the state boards. Similar to the Water Act, the Air Act also authorizes the state boards with the power to obtain information, power of entry and inspection, power to take samples from air emissions, and permits action against company officials in case of contravention of its provisions by a company. The Air Act as well provides for a wide array of penalties ranging from imprisonment of 3 months to 6 years and daily fines in case of continuous violations. consent to establish and consent to operate. The Act requires certain industrial plants to apply for consent from the state boards before establishing or operating any industrial plant in an air pollution control area. The board, while granting consent, may also impose certain conditions which are required to be followed by the concerned industry. Failure to comply with conditions or operating without appropriate consent could result in the closure of the industry. Supreme Court in the case of MC Mehta versus Union of India held that, and I quote, carrying of mining operation of stones on the border of Rajasthan and UP without obtaining necessary permission from competent authority was held to be illegal, and persons were restrained from working out mining activities. Unquote. Number 3. Environment Protection Act 1986. Even though there were existing laws in India dealing directly or indirectly with a vast array of environmental issues, India still lacked a general legislation for environmental protection in India. Due to constantly changing paradigms in the field of environmental law, a need was felt to have an umbrella legislation for environmental protection in India, which would enable better coordination between regulatory authorities and provide for speedy and adequate responses to varying environmental issues. Further, Bhopal gas tragedy also exacerbated the loopholes in the existing system of environmental protection and highlighted the need for an all-encompassing legislation for the protection of environment in India. In view of these issues, the Environment Protection Act was enacted in 1986. The Act gave sweeping powers to the central government, providing that it could take, and I quote, all such measures as it deems necessary or expedient for the purpose of protecting and improving the quality of the environment and preventing, controlling, and abating environmental pollution. Unquote. In particular, for instance, measures could include a restriction of areas in which any industries, operations, or processes shall not be carried out or shall be carried out subject to certain safeguards, laying down procedures and safeguards for prevention of accidents which may cause environmental pollution and remedial measures for such accidents, laying down procedures and safeguards for handling of hazardous substances, examination of such manufacturing processes, materials, and substances as are likely to cause environment pollution. The Act also empowered the central government to make rules by notification on specific issues pertaining to environmental conservation and protection. However, each rule made under the Act is required to be laid before each house of the Parliament. In light of this power, central government has been able to issue notifications on a plethora of environmental issues in India, such as waste management, environmental impact assessment, coastal regulation zone or CRZ, etc. The Act also provides for a penalty of imprisonment ranging from 5 years to 7 years, along with fines, which may extend to Rs 1 lakh and daily fines of Rs 5,000 in case of continuous contravention. Coastal Regulation Zones Notification. The first CRZ notification was issued in 1991. Since then, there have been several changes and amendments in these notifications. The most recent notification was implemented in 2019. As per the 2019 notification, CRZs have been classified as number 1, CRZ1A, which means ecologically sensitive areas which play an important role in maintaining the integrity of coast, such as mangroves, coral reefs, salt marshes, nesting grounds for birds and animals, etc. Number 2, CRZ1B, which means intertidal zone, that is, area between high tide line and low tide line. Number 3, CRZ2, which means developed areas up to or close to shoreline. Number 4, CRZ3. This means land areas that are relatively undisturbed have further been classified as A and B based on population density. And number 5, CRZ4. It deals with water areas and seabed areas and further classified into A and B on the basis of distance from low tide line. The new notification has certain provisions which are favorable for industries and businesses, such as number 1, clearance procedures for projects or activities located in CRZ1 and CRZ4 to be dealt with by the Ministry of Environment, Forest and Climate Change, whereas powers for clearance under CRZ2 and CRZ3 have been delegated to state level with necessary guidance. Number 2, there is a boost for the tourism industry as temporary tourism facilities like shacks, toilets, changing rooms, drinking water facilities have been permitted in the no development zone of CRZ3, that is, areas with a minimum distance of 10 meter from the HTL. Number 3. The notification also lifted the prohibition on construction in the previously protected 200-meter no development zone in rural areas and 100-meter no development zone along the tidal influenced water bodies, reducing it to 50 meters for these water bodies and densely populated rural areas. This will make way for more real estate, hotels, and resorts. As per the 1991 Development Control Regulation, floor area ratio has been frozen. As of now, it stands defreezed and floor space index is permitted for construction projects, which imply a boost for the real estate sector. Waste management rules. In a developing country like India with high consumption pattern and huge quantities of different kinds of waste, lack of proper management and disposal system can be a serious issue. Several rules have been notified in India dealing with different kinds of waste such as municipal solid waste, plastic waste, hazardous waste, biomedical waste, etc. These rules are based on the principle of making stakeholders accountable for the management of waste. Most importantly, the rules stipulate that it is the responsibility of the producers to ensure that the waste generated from their products is disposed of in an environmentally friendly manner. It can be defined as, and I quote, a policy principle to promote total life cycle environmental improvements of product systems by extending the responsibilities of the manufacturer of the product to various parts of the entire life cycle of the product and especially the take back, recycling and final disposal of the product. In India, the principle of extended producer's responsibility or EPR has been an integral part of the waste management rules. The Batteries Management and Handling Rules BMHR 2001 was the first to be based on the concept of EPR without explicitly mentioning it. Thereafter, the rules made for plastic waste, that is, Plastic Waste Management and Handling Rules 2011, and E-Waste, that is, E-Waste Management and Handling Rules 2011, explicitly laid down the provisions for EPR in managing waste. The concept of EPR has received much needed attention in the recent rules formulated for effective management of solid waste. It is one of the most important parts of the E-Waste Rules 2016 and Plastic Waste Management Rules 2016. For the first time, it has also been included in the Solid Waste Management Rules 2016 as well. Plastic Waste Management Rules 2016 illustrates that the primary responsibility for collection of used multi-layered plastic sachet or pouches or packaging is of producers. Importers and brand owners who introduce the products in the market are also responsible for the same. They need to establish a system for collecting back the plastic waste generated due to their products. There are different approaches for successful implementation of EPR. Indore adopted a ward-wise approach and in 1 year achieved 100% segregation of waste at source from households and commercial establishments. The sorted waste is easily saleable to the recyclers. The recyclers are queuing up daily for collecting their category of waste with an assured quantity and quality. Environment Impact Assessment or EIA notification. Initiated formally in 1994, the current EIA notification 2006 lays out a detailed process for obtaining prior environment clearance for any new projects or activities or the expansion or modernization of existing projects and projects seeking capacity addition with change in process or technology. Category A projects acquired their clearance from the Ministry of Environment, Forest and Climate Change, that is MOEFCC, while Category B projects apply for clearances to the State Environment Impact Assessment Authority, that is SEIAA. Category B projects can be further broken down to B1 and B2, thereby determining which projects and activities will require an EIA before approval. Since January 2016, institutions have been created at the district level as well, and they too have been included in the EIA notification for approving certain instances of mining of minor minerals. These are the Direct Environmental Impact Assessment Authority or DEIAA and District Level Expert Appraisal Committee or DEAC. Since March 2016, Ministry of Environment, Forest and Climate Change has adopted a new method of classifying each type of industry. A concept of white industries has been introduced to denote non-polluting industries. They do not need permit or consent and just require to notify the relevant state pollution control board. For other color-coded industries, that is red, orange, green, environmental permits are needed according to kind of activity and size of activity being conducted. A pollution index or PI score is given to each industry depending on utilization of resources, air emissions, hazardous waste generated, etc. For example, red category PI score of 60 and above, including but not restricted to asbestos, nuclear power plants, ship breaking, oil and gas extraction. Orange category PI score of 41 to 59, including food processing, pharmaceutical formulations. And green category PI score of 21 to 40, including sawmills, tires and tubes retreating. White category PI score up to 20, including wind power, mini hydroelectric power less than 25 megawatts. No red category of industries shall normally be permitted in ecologically fragile areas or protected areas. An integrated permit system can be submitted to relevant state pollution control board to obtain consent to establish and consent to operate authorization under various acts or rules. Submit a combined consent application to relevant SPCB or CPCB, that is, State Pollution Control Board or Central Pollution Control Board. In August 2018, a new online environmental portal was launched by Ministry of Environment, Forest and Climate Change named Parivesh, which stands for Proactive and Responsive Facilitation by Interactive, Virtuous and Environmental Single Window Hub to facilitate online submission and tracking of various environmental clearance applications. It allows a single registration and single sign-in for all types of clearances, that is environment, forest, wildlife, CRZ, and create a unique ID for each project. There is a particular period for validity of various permits and most of consent orders EC can be transferred. Forest Conservation Act 1980. The Forest Conservation Act 1980 lays down the provisions that regulate the diversion of forest land for non-forest purposes. This is with the stated objective of ensuring long-term conservation of the forests in India and reducing forest degradation. Any user agency, both government and non-government, has to seek prior permission from the central government before de-reserving any forest land, felling of trees, or before diverting any forest land for non-forest use. The application for the same is moved through the Forest Department of the state government, which is the final point of approval for forest diversion under this legislation. Non-forest use implies the breaking up or cleaning of any forest land for the cultivation of tea, spices, rubber, palms, oil-bearing plants, horticultural crops or medicinal plants, and for any purpose other than re-afforestation. Proposals involving forest land up to 40 hectares, not including activities related to mining and encroachments, are handled by the Regional Office of the Ministry of Environment, Forest and Climate Change. Proposals involving forest land above 40 hectares and those related to mining and encroachments are handled by the Ministry of Environment, Forest and Climate Change. The Wildlife Protection Act 1972. The Wildlife Protection Act 1972 is a statute to provide for the protection of wild animals, birds and plants. It provides for a declaration of national parks and sanctuaries and prohibits hunting and harming of wild animals and uprooting of specified plants in general. A permit is required in case any activity, including industrial, mining or infrastructure, is likely to destroy, exploit or remove any wildlife, including forest produce, from a protected area. A protected area includes a sanctuary, national park, conservation reserve or a community reserve. It is also required in case an activity could destroy, damage or divert the habitat of any wild animal, and in cases where activities are likely to divert, stop or enhance the flow of water into or outside the protected area. This is granted through the Chief Wildlife Warden only after the state government, in consultation with the National Board for Wildlife, that is NBWL, is satisfied that such an action is necessary for the improvement and better management of the wildlife. In case of non-compliance, the permits can be cancelled and punishment can be imposed through imprisonment and or fine.
We were listening to the audiobook by the School of Management Studies, IGNOU, for MBA program. Course code MMPC-013 Business Law. Course Coordinator Professor K. Ravi Shankar. Voiceover by Harpreet Kaur. Edited by Savita Rana. Program assisted by Tarannum Jahan and Jagbandhu Jana. Program produced by Dr. Manoj Kumar Singh. This program was brought to you by Electronic Media Production Center of Indira Gandhi National Open University.